Hello and welcome to IR Thinker, where we explore the complexities of international affairs. I'm Martin Zupko. Today we'll delve into the governance of outer space. As technology advances, space is increasingly seen as a potential domain for future conflicts or even as a platform for launching attacks by international actors. But what do we do about this? What do we know about the outer space and its governance? Is it even possible to establish effective control and maintain order in such an uncharted domain? Let's explore these pressing questions with Dr. Adam Bauer. Hello.
Hello, Martin. It's good to be with you.
Dr. Bauer is a senior lecturer and associate professor in international relations at the University of St. Andrews. He was the founding co-director of the Center for Global Law and Governance and continues to sit on the steering committee of the Institute for Legal and Constitutional Research. He is a fellow of the Outer Space Institute, a global network of transdisciplinary space experts. He is also a member of the management team of the Scottish Council on Global Affairs. Dr. Bauer's research explores the interaction of international law, norms, and political power. So let's speak about the outer space. That's a fascinating domain and topic. And my first question is, do we even have any definition of outer space? Is there any official, let's say, internationally or globally accepted definition? So we can work with the legal framework, we can work with ideas. And also, what's about the consensus about it?
Great. Well, thanks so much. And thanks for that introduction. Very kind. Well, the first thing to say is that there is governance, there is international law that specifically deals with outer space. And yet, and this is, I think, why it's a great question to begin with, we actually don't have an international legal definition of what outer space is. I think we all know it's something beyond Earth, and that's a starting point, and that's a good starting point. But there is no actual definition precisely where, for example, the Earth atmosphere ends, and therefore Earth ends in some sense, and where outer space begins. And partly there's a physical reason for that, and that is that the atmosphere doesn't just stop, right? It really fades out over very long distances. And so there isn't a clear dividing line between where there is an atmosphere, so to say, and where there is no atmosphere. What we've done, I think, and by we, I mean the international community since really the 1950s, is try to think in terms of sort of a functional kind of definition. And the way this has usually been done is to think of it as outer space begins at the point at which conventional air vehicles, so that is aircraft that use their wings for lift or high altitude balloons, an altitude above which they can't operate because the atmosphere is too thin. And indeed, outer space must begin below the point at which a satellite could continue to orbit the Earth without requiring constant propulsion. So that usually gives you a boundary of something around 100 kilometers above the mean sea level distance. And that's the standard that's utilized, for example, by the Fédération Aéronautique Internationale, the FAI, which is a major international body. So 100 kilometers is a kind of more or less, let's say, standard definition. It's something that's known as the von Karman line, which was initially coined by, I believe, a physicist, von Karman. But it's a bit of an arbitrary distinction because you could really say you could go a little bit below or indeed above that dividing line. Other physicists, astrophysicists like Jonathan McDowell have proposed 80 kilometers as a more functional altitude, but there isn't one set definition. And that's actually partly been, and there are, by the way, there are ongoing discussions at the United Nations Committee on the Peaceful Uses of Outer Space, on their legal subcommittee. There have been ongoing discussions as to whether or not it would be possible to provide a more precise definition. But interestingly, some major space actors, the United States, for example, have always taken the view that it's not really important. It's not critically important to the functioning of outer space law or indeed terrestrial law to have a distinction or a very strict legal dividing line. And partly that's because the US views, for example, the US views that the idea that technology may change. So, for example, it might be conceivable to develop an aircraft that can fly at a higher altitude, or indeed satellites that are able to operate at lower and lower altitudes. For example, there's some experimentation with what's known as very low Earth orbit, below about 160 kilometers. And that would allow for satellites to utilize propulsion part or most of the way through their orbit, but to be at lower altitudes. So the point being that there is not one clear distinction or one clear legal definition of outer space, but we can say broadly that the key important thing when we think about outer space from the perspective of human uses of space, and therefore the legal definitions that follow or the legal mechanisms that follow, is that you're really looking to be at a point at which an artificial satellite can continue to orbit around the Earth in order to maintain its functions. And most satellites that are in Earth orbit are above an altitude of at least 300, 350 kilometers above mean sea level. So for example, the SpaceX Starlink constellation is largely clustering at about 550, 570 kilometers above the Earth. And so that starts to give you a bit of a sense of where we might begin from. That's a sort of a definitional question. As I say, there is not one legal definition, but for the most part, international lawyers, space governance people have been able to operate, I think, quite well with a sort of slightly blurry definition, in part because there hasn't been a lot of the so-called border cases. We don't really have a lot of incidents of either Earth, conventional aircraft being able to exceed existing technological capabilities, or indeed satellites being able to go below in altitude what we've been experiencing up till now. So there haven't really been threshold cases that would call into question whether space law was operating or terrestrial law was operating. Maybe one last point on this before I just sort of talk about a little bit about the consensus question is that while we don't have this strict legal definition between terrestrial and space, from a space law perspective, that's also not so important, because we also find in the Outer Space Treaty, something we'll talk about, I'm sure, more later, that all terrestrial international law, general international law, continues to operate in the outer space environment to the extent that it is governing, human-based, either human activities or human-designed activities. And therefore, the distinction still is not entirely critical insofar as it's not as if Earth-based law, terrestrial international law, stops the second we move out into outer space. So that's that sort of definitional question. On consensus, and this is, again, I think something we'll probably come back to through the discussion, most of the international institutions, particularly the UN institutions, Conference on Disarmament, UN Committee on the Peaceful Uses of Outer Space in particular, utilize consensus decision-making in order to develop rules and principles. And that has its benefits because, of course, in this kind of a domain, it's important to try to bring in all of the major players and indeed smaller actors that have important concerns over the continued human uses of outer space, and to get them to agree on standards rather than to have them negotiated and agreed without that kind of buy-in. But again, as something I think we will talk about throughout our discussion, I mean, what this leads to, of course, is a slower process. And indeed, I think from my perspective right now, we're in a time period where there really is not a lot of fundamental agreement among all of the space powers as to the most important issues going forward, or at least how to address them in a multilateral setting. And that has therefore led to a kind of a slowdown in the production of new legally binding rules. But there are a number of really interesting governance processes underway that seek to address not only space security issues, but also sustainability and safety issues. And indeed, those categories are ones that really increasingly interact and are hard to keep separate. And so there's quite a bit of dynamism and interesting work going on in outer space governance. But much of it is not, at least at the moment, taking place through the kind of legally binding negotiations, multilateral treaty making, for example, that some or many would hold out to be the gold standard. But I think that shouldn't prevent us from recognizing that there's actually an awful lot of really interesting work and initiatives underway, because precisely as you said in your introduction, outer space is increasingly important to the way we operate on Earth. And while I still think it's a ways off before we really live and operate and have real economies in outer space, I think that's still a long way away. It's definitely the case that we are, for example, seeing a large number of missions to the moon, a return to the moon, and that in turn will be pushing us a little bit beyond where we have been principally in Earth orbit, low Earth orbit, over the last 30, 40 years as the main area of activity. So a lot going on, but also a lot of really important challenges as we accelerate uses of outer space, both in Earth orbit and beyond. That's creating a number of environmental problems, concerns for accumulating space debris, or indeed even active satellites, and managing the traffic flows, if you like, in low Earth orbit. but also competition and potentially even sources of conflict among space operators.
And I have two remarks. The first one is the perception. Because when people or students, they see the space, we usually see space either in the pictures or photographs, or we see that international map and the International Space Station is flying across the map. So automatically we think, well, now it is above the France, so it's like French space. Then it's above Russia or United States, so it's their airspace. And this is, I think, that sort of misleading perception of the space. And the second one, when we speak about the governance, there are private actors, and this is something new that wasn't before. And some people might wonder, like for instance, Elon Musk wants I don't know how many satellites around the globe. Who is going to say yes, he can do it, or no, he can't do it, because it impacts the whole space around the Earth. So I think these are two interesting perceptions, and also the challenges why we need a better governance. When we speak about governance, let's go more specifically, Adam. And how do you see the key international norms that guide international space relations today? Because you said that there is sort of uncertainty around, but still, do we have any treaties? Do we have any maybe agreements that we are following? And the second question following this one would be how the geopolitics and how those states react to that treaty.
Sure. No, thank you for that. So the first thing to say is, and I mentioned this already, there is a body of space law. And indeed, actually, in my view, outer space law is a really interesting, important, quite dynamic, admittedly niche field of international legal study, but it's one that really is interesting, dynamic, and important. So if we're thinking from the perspective of formal binding law, treaty law, you can look to be there are sort of 5 core UN space treaties, and there are a set of then additional principles and declarations, 5 sets of principles, declarations, and that is usually held out to be the core of international space law. And I won't go through all of those. We could be here all day talking through all of the dimensions of that. What most people would point to being as key or most critical and important is the 1967 Outer Space Treaty. And the reason for that is a couple of reasons. First, the Outer Space Treaty is the first international space treaty. It's the one with the widest membership. I think it's something like about 118 or 120 now states parties. And it is also the treaty that establishes the foundational principles for outer space law that have been refined and extended in subsequent documents. So in a way, and this is not a perfect analogy, but I think the Outer Space Treaty can be thought of as something like a constitution for outer space law. Not in the sense that it provides legal protections for individuals in the same way a constitution might do, but that it establishes the foundational principles. And so there really, I would point to 4 that are the most important, the ones that we can kind of keep in our mind when we are assessing contemporary international space activities. And so the first of those is found in Article 1, which right at the beginning of the Outer Space Treaty says that the use and exploration of outer space is free. There should be free access and use of outer space to all states because it's a very state-centric legal regime. But that freedom of access and use of outer space should be for the benefit of all and without discrimination. Now, that's interesting because that second part, for the benefit of all, raises questions as to whether the major spacefaring actors are expected in an ongoing way to be sharing whatever these benefits might be. So, for example, are spacefaring actors supposed to freely share Earth observation imagery to the international community? That would be one example. Or in the future, if there were technological capacity to allow for mining in outer space at scale, would that be something that should be shared with the international community as a whole, with other states? But that's principle 1. So freedom of access and use. But that's tempered and conditioned and constrained by the second major principle found in Article 2, which says that in going out into outer space, actors, and here we mean states, may not lay claim to celestial objects, the moon, asteroids, other planets, and other celestial bodies. They may not occupy or make claims of sovereignty or appropriation over celestial objects. So your spacefaring actors are free to go out into space, to explore, to utilize space for scientific, civilian, other purposes. But in doing so, they may not appropriate celestial objects. They may not make claims of sovereignty. And that's very closely connected to the time when space law emerges through the 1950s and 1960s. We can think of this right in the core of the decolonization movement, and a recognition that those kinds of territorial acquisition had been a major driver of human misery, but also conflict and tension among major powers going back many centuries. So there's an attempt in space law to foreclose that possibility right from the outset. So those are the first two principles: freedom of access and use, but non-appropriation and no claims of sovereignty or territorial occupation. The third principle really is one in which outer space is supposed to be utilized for peaceful purposes and under international law, in accordance with terrestrial, we would say, international law, including the United Nations Charter and bodies of international law, which would include things like the laws of armed conflict, international humanitarian law, and indeed other bodies of international law. And another element of that sort of peaceful purposes and international law is a notion found in Article 9 of the obligation to cooperate and act with so-called due regard for the needs and interests of other spacefaring actors. So to be respectful of the other actors that may be operating in the same domain, because outer space is a very hostile environment. It's incredibly cold, it's high radiation. Human beings cannot survive there. Even robotic machines are degraded by radiation and by the environment around. So it's a very difficult place to operate in, and that sort of comes to a logic or a need for cooperation and respect for the operations of other actors. And then the last principle, connected to the last one that I just mentioned, relates to the ideas about what is permitted and prohibited with respect to peaceful purposes, and specifically an idea that there are some relatively modest limitations on military activities in outer space. So the Outer Space Treaty in Article 4 says that it prohibits the stationing of weapons of mass destruction in outer space. And this connects very closely to nuclear arms control through the 1960s. There was a famous test in 1962 known as Starfish Prime, where the United States detonated a nuclear weapon at about 400-kilometer altitude to see what the effects would be. It's not a concern for blast, really, because you're in a vacuum. And so it's not the blast of a nuclear weapon that would be problematic. It's the radiation and the huge discharging of electromagnetic particles, the electromagnetic pulse. So anyway, this test effectively kills a number of satellites that were in orbit at the time, including a Soviet satellite, probably 6 or 10 of the satellites in orbit, which was, there weren't that many at the time. So very quickly, the international community recognized that nuclear weapons testing or use in hostile conflict would be hugely problematic, and so prohibited that. The Outer Space Treaty also says that conventional weapons and military activities are prohibited on celestial objects, that is to say, on the moon or on asteroids or on other planets. It doesn't say anything about the stationing of conventional weapons in orbit or in the voids between celestial objects. So we have then a relatively limited but important set of prohibitions. So if you take those four principles together, that gives you really the foundation, in my view, for thinking through a lot of the challenges that we have in outer space today, ranging from potential arms races or the military uses of outer space through to questions of resource extraction, human habitation on the moon, the challenges that are coming from large constellations of satellites. This is to your point about commercial operators and others. And so my starting point would be to suggest that while more law may be beneficial and the refinement of law is certainly important, and that may involve the development of legally binding treaties or indeed voluntary norms or transparency confidence building measures. While all of that is important, we do have a body of law that we can utilize. And actually, I think there's the quite persuasive argument being made by some space lawyers that what we really need to do right now is use the law we have better, make more use of it in public statements and as a framework for assessing, interpreting, and where necessary, critiquing behaviors. So that's sort of the question of principles. Just if I could quickly say on the geopolitical question around treaties. My reading of this is that for the most part, major spacefaring actors don't really have a problem on the whole with the core principles articulated, for example, in the Outer Space Treaty, chiefly because they were the ones that negotiated them, particularly the United States and the Soviet Union, right? The Outer Space Treaty is an international document that was adopted by the UN General Assembly, but it really was one that was negotiated largely by the US and Soviet Union as the two major space powers. So China had less of a role, for example, at the time. But the principles, as I've said, are quite broad. So they don't really provide a lot of very specific thou shalt or thou shalt not kind of language that could be used to critique specific behavior. So they're a framework more than a very rigid set of rules. Maybe one example, though, where we were seeing an immediate tension is you might have seen reports coming back to February of this year where the United States, initially through, I think, a congressman in the United States, announced that he had understanding that the U.S. administration, the Biden administration, had intelligence to suggest that the Russian Federation was either developing or had already placed a nuclear device, so to say, in orbit. Now, if confirmed, that would be a clear violation of the Outer Space Treaty, one of the relatively few, as I've said, clear, bright line rules that outer space law has in that respect. I don't think we've really found any final resolution to that question. It's something the Russian Federation denies. But in broad strokes, I think outer space law suits major spacefaring actors. And indeed, they are in different ways interested in refining and developing space law further. China and Russia have been active proponents of a treaty banning the placement of weapons in space in the past. More recently, the United States and Western allies have become more interested in developing a body of norms around responsible behavior in space and so forth. So for the most part, this is an area where I think the spacefaring actors see a relatively permissive environment that they can operate in now, but are also increasingly recognizing the need to provide more rules of the road.
As you stated, Adam, this treaty is very state-centric, but this was 1967, I think. Today it's 2024, and we have some private actors. So do we have any treaty that is taking care of the private sector? Or, for instance, when a private company is launching some satellite or object to the space, is this considered as a state sort of object because the company belongs to, I don't know, France, United States, or Russia? Or is it the private object, which basically the international treaty doesn't mention?
Yeah, this is a really important point, and it's something that you mentioned sort of or alluded to in your last question, and I didn't answer there. So now's a great opportunity to do so more clearly. International space law is really interesting in that, to a much greater degree than the rest of international law, it is entirely state-centric, really. I mean, if you look to the Outer Space Treaty, it says basically explicitly that all spacefaring activity, and this would include, therefore, civilian space activity, commercial operations, etc., all of it are the responsibility ultimately, and indeed the legal liability attaches to the state of registration. So that is to say that all spacefaring activity that takes place out of the United States is the responsibility of the United States government as the state of registration. That was a very deliberate choice in the 1960s. You're right to say that there wasn't a lot of commercial activity, but it wasn't entirely unknown. I mean, for one thing, aerospace companies were building rockets for the United States, for example, and it would not be long before we would have some commercial telecommunications based in geostationary orbit. But the Soviet Union was very clear that that was, incompatible with their ideological worldview, and so there's no mention of commercial operators anywhere in the Outer Space Treaty. So what we have is a legal regime that requires all space activity to be registered. And so the United Nations maintains a registry of outer space objects. It's not entirely complete. Major spacefaring states, for example, tend not to register their classified spy satellites, as an example. But there's reasonably good adherence to this requirement to register all space objects. And from that point, the responsibility for their operation and the legal liability in the event of accidents would attach to states. So what that really means in the end is that, we are now in a very interesting situation. As you mentioned, Elon Musk and SpaceX. SpaceX alone operates something like 55 or 60% of the active satellites in orbit. SpaceX is, by volume, by number of launches and by payload volume or mass, overwhelmingly the largest space launch actor in the world. And so you can count them as an American asset. And I think this is actually a really interesting international relations question, is the extent to which a space company is, strictly speaking, kind of an enabler of state power versus perhaps a challenge to state power insofar as companies may have different interests than their home governments in certain situations. But for the purposes of space law, what SpaceX is doing in orbit is the responsibility of the United States. And therefore, governance of space, commercial space operators, ultimately comes on a second order as domestic regulation. So spacefaring actors have a responsibility to develop national space law and regulations. For example, things like regulations on launching or the operating of satellites, in order to ensure that the actors that operate under their jurisdiction are in compliance with international obligations. So that's the principal way. There are a few other instances in which commercial operators are a little bit more directly interacting with international law, but we could leave that aside for the moment. As I say, what I think this really does do, though, is introduce some very interesting questions around the relationship between public and private capabilities, especially now as we're seeing governments are increasingly reliant on commercial operators. The war in Ukraine is really the great case in point for this, and SpaceX Starlink providing commercial telecommunications, broadband internet to the Ukrainian government, Ukrainian civilians, and the Ukrainian military. And a lot of the intelligence collection that is going on over Ukrainian territory, and indeed elsewhere, is being provided by commercial Earth observation and remote sensing companies that are providing that data to the US government and NATO allies and the Ukrainian government, for example, on a contractual basis. And those are really interesting questions. International space law has an answer in terms of the legal responsibility and liability, but there are a whole set of other political questions that connect to international law that come out of this changing relationship between state capabilities and increasingly diverse and important commercial capabilities.
One of those questions is, and I discussed this with one of my friends, for instance, there is a satellite belonging to the United States in the space. Russians are going to destroy the satellite because, for instance, they want to block the Ukraine sort of research and they want to control the space. And then the question is, was this attack on NATO as on one state, which basically should trigger the response from NATO? And I think this is quite a complicated question because you have different domain. So people might argue, is NATO agreement or treaty covering only Earth, or is it covering the outer space?
Well, I agree with you. It is complicated, and I think one of the things I'll say to begin is that international space lawyers, colleagues of mine, are thinking very carefully about these questions, and so they would have fuller answers than what I could give. But let me take a shot at this. I mean, one thing to say just on specifically on NATO is that I think it was from 2019, or certainly more recently, NATO has officially characterized outer space as an operational domain, and has, as I understand it, also recognized, therefore, that the assets of NATO members, should they be targeted, could be interpreted as an armed attack, which could in turn justify an invocation of the Article 5 collective defense clause. There is a kind of conditionality to that, right? Because it would really depend, in my view, on the nature of a potential attack in a couple of ways. So maybe before getting into that, just to say quickly, there has fortunately never been an incident where one country has deliberately physically destroyed the satellite of another using military capabilities. There have been a number of accidents between between satellites collisions, those are all accidental to everyone's understanding. What we do know is that cyber attacks against satellites are increasingly pervasive. Certainly since 2022, this has become increasingly common for commercial operators in particular, reporting publicly or privately that they face continuous, often cyber attacks, attempted cyber attacks. Jamming and spoofing of satellite signals is also very common. And there's probably some evidence to suggest that ground-based lasers have been utilized to temporarily dazzle the sensors, the optical sensors in particular, of Earth imaging satellites. Now, it becomes an interesting question. Do any of those rise to the level of an armed attack that would justify a response, self-defense? Probably not. Probably not. But again, it would really depend on the context. To just take it one step further, in public diplomatic fora in the United Nations General Assembly, for example, the Russian Federation has stated publicly that they believe that if a commercial satellite, let's say one of the SpaceX Starlink constellation, is providing meaningful military capability to one side in an ongoing armed conflict, that would then make that satellite a legitimate target under the law of armed conflict. Again, one of the challenges would be to determine which satellite is doing what and at what moment. There are currently something like 6,600 Starlink in orbit. They pass over a given part of the globe very quickly. I mean, an orbit of one satellite will be 90 minutes. So the whole point of a Starlink constellation is that satellites are moving over the territory very quickly and handing over the responsibility for, in this case, broadcasting down broadband internet capability, is handing over to satellites on an almost continuous basis. So knowing which satellite was responsible might be a key issue if you were saying it was a single satellite or a limited number of satellites that were the ones that were the legitimate target. On the other hand, something like Starlink, all of them are, in a sense, are in practice doing the service, but there's so many of them that hitting any one of them would be, from a functionality point of view, the system would carry on. Now, the creation of debris in orbit would be another issue, and that would probably be where we start to get into really serious concerns about both the threat or the risk, but also the long run consequences. Destroying satellites in orbit creates debris. That debris can stay in orbit for quite a long time and therefore imperils other satellites. And this becomes especially problematic as we have more and more satellites at particular altitudes. And just quickly on that, I'd refer your reader or your listeners, if you're interested in this, the Outer Space Institute has done some very interesting work on the consequences of kinetic satellite attacks. You can find that research on the Outer Space Institute's website, and I've contributed a little bit on the margins to that work. And I think it's an important demonstration of the risks that we face if we get into armed attacks against satellites. My main point, just for the moment, would be that, exactly as your question, Martin, raises a whole set of interrelated questions. My view is that they would really be very contextual. And so ultimately, if we want to understand the risks to satellites, we have to kind of go back and ask, what services are they providing, and in what context and for what reason? And that then leads to a set of assessments potentially on the legal nature of, for example, the legal legitimacy of a potential armed attack, but also the right of a response. The last thing to say is all of this is kind of highlighting the extent to which, as I mentioned before, we're seeing an interpenetration, if you like, between state capabilities and commercial capabilities. Space systems are inherently dual use in the sense that basically every technology can have a benign civilian, indeed a commercial benefit or use, but could be repurposed in one way or another to be hostile or to enable military operations on Earth. So Starlink, for example, is a great example of that. It is an absolutely critical enabler of internet connectivity for civilian and governmental services in Ukraine. The same system is being utilized by the Ukrainian armed forces. We can use Earth imagery to monitor natural disasters or to detect military formations on a battlefield. And indeed, something like in orbit, a robotic arm that might in future be utilized to repair a satellite that has been damaged and therefore have a really beneficial effect on helping to enhance space sustainability and indeed the commercial longevity of a space asset. That same type of capability could in principle be utilized to damage a satellite or pull it out of an orbit in a hostile manner. This is one of the great challenges, I think, for space law and governance is there are not clear distinctions between civilian capabilities and military capabilities. And indeed, technologies could in principle be utilized for entirely benign and beneficial or indeed hostile and damaging purposes. So that's kind of a long way of saying that the kind of questions you're asking around the interface between kind of the legal rules and principles and the application of technology is really challenging and comes back ultimately to a set of assessments about a particular event in the world at a moment in time. But as I say, we do have a set of principles that can at least help guide us as to what might be permitted and not permitted.
Absolutely. And I've seen the map of space debris. I don't remember from which institute, but I was wondering how is it possible to even launch a rocket? Because there are thousands of pieces, and it's like from 2 millimeters to 5 centimeters, and they are traveling super quickly. So that's a real problem. But Adam, let's briefly evaluate what's going on now in terms of international multilateral forum. And I would like to ask you, what are the strengths and limitations that you see in the current structure of international institutions, particularly, for instance, the UN Conference on Disarmament, where those issues might be addressed? And also maybe you see some sort of maybe room for improvement or some ideas that you would like to see in those multilateral forums.
Well, I mean, I think the first thing is that we have a very complex international society now, and I think one from a broader perspective, my sense is that we really are entering a period of kind of governance fatigue. Not to say that it's unimportant, but just simply that there are so many complex issues that need to be addressed, and the ability to develop multilateral fora to respond to all of them in a timely fashion is perhaps exceeding our capacity. And I don't want that to sound excessively negative. I think there actually is a lot of potential for us to develop better international governance responses on a range of issues, notwithstanding the fact that there are genuinely different perspectives on what the appropriate way forward might be. In the context of space governance, I mean, you mentioned the Conference on Disarmament. And this is, of course, the principal multilateral forum for the negotiation of disarmament and arms control agreements in the international system. And it operates on consensus. And there's a good reason for that, that I mentioned earlier on in our conversation, is that in developing so-called hard security agreements, you really need all of the major players to be willing to accept those rules. And therefore, consensus is deemed to be necessary in order to produce meaningful, widely accepted standards. But the Conference on Disarmament has been essentially completely deadlocked since the late 1990s. They have not even been able to agree on a program of work since, I believe, 1997 or 1998, due to certain delegations' concerns over what might be included in that program of work. So the Conference on Disarmament effectively is a dead end right now. And we've seen this in outer space governance since the early 2000s. The Chinese and Russian delegations have tried to promote a treaty banning the placement of weapons in outer space. They wanted to do this via the Conference on Disarmament, but that had really no prospect of going forward. There has been more success in the UN Committee on the Peaceful Uses of Outer Space, which, as the name suggests, does not deal with security matters, but deals with safety sustainability type issues that are very, very important. So, for example, the UN Committee on Peaceful Uses of Outer Space agreed the long-term sustainability guidelines in 2018, 2019, and there are a number of working groups and different initiatives on a range of issues that are actively working. It too operates by consensus, and that is difficult, particularly in the current international climate, where there is, I think, everyone listening will agree, we are in a period of considerable mistrust and major spacefaring actors do not agree always on the right way forward, but also some delegations, I think it's fair to say, might regard it as beneficial to just slow the process down, whether that's out of a strategic interest in limiting the expansion of rules or frankly out of something like spite. So consensus is a challenge. I'm not sure that there's a good way around that in the present environment. I mean, one thing to think about might be whether or not it always is essential that all of the major actors agree. So the consensus rule has a logic to it, but there have been examples in relatively recent history where states and non-state actors have worked together to develop big multilateral treaties outside of consensus. And I would refer to mainly, for example, the Anti-Personnel Mine Ban Treaty, the Convention on Cluster Munitions, the Treaty on the Prohibition of Nuclear Weapons, and the Rome Statute of the International Criminal Court. And indeed, I wrote my doctoral dissertation and first book on the landmine ban in the ICC as examples where so-called middle power states and civil society banded together to promote much more rigorous international rules than militarily powerful states like China, the United States, Russian Federation, and others were willing to support. And in my view, both of those institutions that I've mentioned, the Mine Ban Treaty and the ICC, have been successful in different ways, although they've had many challenges. Now, you don't see that happening in space. I don't think there's any real interest among spacefaring actors to go outside of the Conference on Disarmament to develop a binding multilateral treaty. What we are seeing, though, and this is where I'll end my reflection on this question, is that we are seeing a set of initiatives that are seeking to develop transparency, confidence building measures, or norms, voluntary norms, around responsible space behavior as an alternative approach to developing further guidelines. And an idea that, and this is something particularly that's being supported by Western states, an idea that binding multilateral treaty for space security is not really a viable pathway right now for a variety of reasons that we can get into. And instead, what would be necessary is to begin by getting spacefaring actors together to discuss their perceptions of responsible or irresponsible behavior, safe or threatening behavior, and use that as the baseline to develop a set of norms in that respect, which might, in the fullness of time, be developed into a binding legal treaty. But the preference in the West, I think it's fair to say, for the most part, is to go the route of voluntary norms for now. And that then introduces a tension between two different views as to what the preferable pathway forward on space security governance is, whether that binding multilateral rules or voluntary norms, which can still have very important behavioral effects.
President Putin, President Xi Jinping, they speak about different international order based on multipolarity. How this multipolarity is reflected in the outer space governance? And do you see any activities coming from non-Western countries? For instance, we have the BRICS group, we have the Shanghai organization, and others. So how is this sort of the vision for different world, different order reflected in the outer space governance?
Sure. I mean, I think, well, so the first thing to say is that, China is, I mean, you can measure this in different ways, but China would be probably the second space power behind the United States, and the gap between them has closed. I mean, the Russian Federation has really declined as an international space power in terms of capabilities and international influence. Not just since 2022, although that was, I think, in my view, a precipitating factor for a further decline. But China is really a rising space power, and to my mind, there's too much talk, particularly in the United States, around the idea that there's an inherent and necessary conflict with China coming in outer space and indeed on Earth. But nonetheless, that this is at the very minimum a competitive environment, and probably one that the values and interests do not fully align. I wouldn't overstate that, though, because I think all spacefaring actors actually do have an interest in maintaining Earth orbit as a safe and sustainable operating environment, not least because China derives tremendous benefit from Earth orbiting satellites and has very ambitious plans for lunar development and beyond. What I would say, though, is in broad terms, If you're thinking of space security governance, and this could go to other types of governance, for example, plans for lunar governance, there are, two kind of big views right now. I had mentioned before, since the early 2000s, China and the Russian Federation have promoted a draft treaty on the placement of weapons in outer space, often shorthanded as PPWT. And this was an attempt to provide a legally binding set of rules to prohibit the placement of some weapons in outer space. And there are a variety of technical questions around what it covers and doesn't cover. That's never been something that the Western states, the US and others, have liked. They've always resisted it for a variety of reasons. And so you can see then, particularly over the last 4 or 5 years, the emergence of, as I mentioned already, this alternative approach, this idea that what would be preferable is not to go the route of trying to negotiate a legally binding treaty to target certain technologies in a certain orbital regime, for example, but rather to develop a set of principles that are much more focused on the behavior rather than the technology itself, and that could begin as voluntary norms, but that could perhaps be developed into legally binding instruments over a longer period of time. So in my view, in space security governance, we really see a sort of a bifurcation into kind of these two different approaches. It's a really interesting question then as to where so-called global South states, I don't love that term, but for the moment, let's just use global South as a kind of imperfect shorthand. Where do they fall into this? And I think what's interesting is that many of those countries kind of go across both approaches and want to contribute to both. Countries like Brazil and the Philippines are making really important contributions right now to some of these space security governance discussions, and could potentially serve as a quite effective bridge between different positions. My view is that the approach to a legally binding treaty on weapons or technologies and a behavioral-based norm development approach are not entirely incompatible, but they are at least geopolitically seen as, by the main leaders of these different approaches, are seen as distinct and largely irreconcilable in the present moment. But I think that there may be opportunities to bridge across the common ground. And frankly, I think that that's something that will benefit from other states rather than simply just expecting that the United States and China, for example, will figure it out on their own. And there are a number of so-called smaller space states that really do have an important role to play, and that I think are increasingly active and are making really sophisticated contributions. I named Brazil and the Philippines, but there are a number of others as well. And the reason for this is simply that while not every country has a fully developed space program, most countries do not launch their own satellites with their own rockets from their own territory. But everybody is benefiting from space-enabled services. And therefore, there's a growing recognition that the preservation of Earth orbit as a sustainable, safe operating environment is critically important. And in addition, there are a number of smaller countries in spacefaring terms who may not have their own lunar exploration programs, but are very concerned as to what might be occurring on the moon or beyond, and have a vested interest in making sure that the big spacefaring actors, so to say, are behaving in a safe, sustainable, and responsible manner.
There is an article written by Adam and Jeffrey Lantis, Contesting the Heavens, US Antipreneurship and the Regulation of Space Weapons. And in this article, you and your colleague, you argue that, if I quote, we argue that answers to these questions can be found in identifying US diplomacy as an archetypal example of antipreneurship, a form of strategic and defense norm competition designed to resist changes to the normative status quo in the face of entrepreneurial efforts. And you refer to sort of activities of Russia and China, how they wanted to propose something and the United States resisted. And my question would be, why? And is this concept that you are elaborating on in the paper something that it's a big challenge to better governments of the space?
Sure. Well, thanks for that, and thanks for mentioning the article. Yeah. So really, I mean, the beginning of this article was an attempt by Jeff Lantis and I to understand a little bit more the dynamics around space arms control proposals from the 2000s forward. And I've mentioned now a couple times this PPWT treaty proposal from the Chinese and Russians, which had sought, and it's still an active document, so to say. It hasn't been negotiated into a legally binding instrument, but it still exists. And the PPWT, in short, seeks to prevent and prohibit the placement of weapon systems in Earth orbit. And this was really, in our view, stimulated by long-running Chinese-Russian concerns that the United States may reactivate plans from the 1980s for space-based ballistic missile defense. This is often known colloquially as Star Wars, the Reagan administration's plan. Now, there are huge and, in my view, probably insurmountable technical challenges to stationing ballistic missile interceptors in Earth orbit. But nonetheless, in the early 2000s, when the Bush administration withdrew from the Anti-Ballistic Missile Treaty, that triggered, I think, considerable alarm in Chinese Russian circles that this might be something that the US would contemplate again. And so the PPWT, in one way, could be read as an attempt to foreclose the legal possibility, foreclose the possibility through legal means for the United States to pursue this route, even if it wasn't very likely. So anyway, the PPWT is proposed formally as a treaty text in 2008 with a revised version in 2014. And the United States and other Western allies have always regarded it as a non-starter for a couple of reasons that I'll just quickly mention. The three major complaints from the Western perspective are that the treaty never defines what a weapon is. And indeed, as I mentioned already, since technologies inherently could be dual use or dual purpose, it's very difficult to really define what a weapon would be for the purposes of an arms control agreement in this context. Again, I'm not sure that's insurmountable because, for example, the chemical weapons conventions had to deal with, dual use technology in the form of chemicals, biological weapon, toxin weapons conventions similarly. But nonetheless, this was a major complaint. Second complaint being that focusing on weapons based in space from the view of Western countries misses the fact that the biggest threats to space systems emanate from Earth. Ballistic missiles used to kinetically impact satellites, lasers, cyber attacks, and so forth. The third complaint is that there's no attempt to develop a verification mechanism, and the US position has always been that this is inherently an unverifiable kind of instrument. So in any case, the United States in particular has always opposed this agreement and has sought to block its development in the Conference on Disarmament. And so what Jeff Lantis and I had sought to do is understand kind of the dynamics through which they did this. And we focused on three different kinds of strategies of antipreneurship. So rhetorical, procedural, and behavioral, and then a set of tactics that come with them. And the main point here, though, is that we don't take a normative position. We don't say the United States is wrong to oppose this treaty. And in fact, I think there are a number of problems with the PPWT text. Now, maybe those could be resolved through good faith negotiation, but our point isn't that the United States is right or wrong to oppose the treaty. It was to focus on the tactics, the strategies and tactics that they utilized. The point with antipreneurship is, the name sounds negative. Anti is right in the concept's title. But the point is really just to focus on instances where instead of seeking to promote new norms, so entrepreneurship in the IR scholarship terminology, or to challenge the legitimacy, the meaning, the interpretation of existing norms, and that's sort of the growing scholarship on contestation, that there's this third category, that there might be instances where a country or an actor is more or less satisfied with the status quo, with the norms as they are, and rather than seeking to promote new norms or challenge the norms that exist, is simply seeking to preserve them as they are, more or less. And so that's really how we sought to utilize the concept of antipreneurship, which was really coined and popularized by Lincoln Bloomfield and his co-author Shirley Scott. Now, that's sort of where we come to. What's interesting, though, a little bit in that story is that antipreneurship, in our view, quite nicely captures the US position from 2000 through to 2020, 21. But then you do start to see a growing comfort in the United States with the idea that some gradual development of new norms, focusing on behavior rather than technology, would be an appropriate way to add additional rules of the road. So there's a subtle shift towards the end of our narrative of the United States moving from, strictly speaking, purely an antipreneur, that is to preserve what exists and prevent anything new from emerging, to one that is comfortable with new norms, but that seeks to shape the process, along with other countries, towards an approach and a content that it's more comfortable with. And the last thing I'd just say again is, from our perspective, there's no need to analytically take a position as to whether this is the right or wrong approach. People have different opinions on that. For the purposes of the paper, what we were seeking to understand were the strategies, the tactics, therefore the processes through which this process played out.
The last question for today's interview, Adam. You done the research and you are into the topic, and my question would be about the binding and non-binding norms. How your research has changed your perception of voluntary norms, and what do you think is the future implication and implementation of them?
Well, thanks for that. I mean, it's a hard question, but I think thinking back, right? My starting assumption, and I think it's a starting assumption that many people have, is that binding international law is the gold standard. And certainly when you talk with international lawyers, that's quite understandably their usual starting position as well. And I think that makes a lot of sense. Binding international law does provide a certain measure of clarity and ultimately should be enforceable and so forth. But, as we see with much of international law, enforcement is very difficult at the best of times, whether you've got a treaty or not. What I've kind of found through my research, starting from the PhD and really up to present, is that so-called voluntary norms still can have very important behavioral effects. I mean, countries and other actors, civil society actors, sometimes corporations, are sensitive to the social environment in which they operate. They have a vested interest in being regarded as good actors. Not always. Not all countries, not all companies respond to these social incentives to the same degree at the same time. And there is good faith disagreement on top of that as to what certain norms permit, prohibit, and so on and so forth. But that actually social standards of appropriate behavior, can actually structure and govern the way in which actors operate. As I mentioned before, my doctoral research and then subsequently published in my first book, I looked at the implementation and the effectiveness of the Anti-Personnel Mine Ban Treaty and the International Criminal Court. And one of the strands of that research was looking at how powerful non-party states, China, the United States, Russian Federation, and others, responded to the two agreements. And what's interesting is that while those countries would continue to say that the treaties were not binding on them and they didn't respect them and didn't wish to implement them, the treaties have had important effects as norms, as in informing the way in which those countries and others speak about appropriate and inappropriate behavior, how they justify their behaviors, whether that's in conformance or violation, and often have shaped policy decisions in important ways as well. In space governance, my own view is that whether or not binding international law is the gold standard, it just simply isn't viable right now. The international system, such as it is, and more importantly, the geopolitical situation is such that I cannot foresee serious multilateral negotiations on space security issues over the coming years. But I do think there actually is potential for the development of norms, whether that's through the processes like the open-ended working group on responsible behaviors, which was launched in 2022, 2023, and will have a subsequent format in the coming year or two. There is, by the way, a parallel process, another open-ended working group that's seeking a more legally binding mechanism, an attempt to take the PPWT forward. Now, those seem to be clashing, but on the other hand, there might be potential for bringing them together in productive ways. I think most spacefaring actors increasingly see Earth orbit as potentially really threatened by the accumulating mass of satellites and debris and the sheer volume of activity that you've alluded to before. So my hope would be that recognizing that everyone is vulnerable in space because debris orbits at very high velocity, at very high speeds, and through eccentric orbits, which can cross over the paths of operational satellites. recognizing that inherent vulnerability coupled with our really very deep reliance on space-enabled technology for Earth life, that is the kind of starting point for taking seriously governance mechanisms. I think voluntary norms around things like safe and responsible behaviors in orbit. So, for example, trying to find agreement around how close one can approach the satellites of another operator, whether that's in terms of a physical keep out zone measured by distance or something else, attempts to standardize, for example, automated collision avoidance mechanisms within mega constellations, so sort of norms and standards of operating procedures around space traffic management, whether that's the sharing of space data, whether that is thinking in terms of options for developing norms around things like moratoria on the testing of kinetic anti-satellite missiles, like the United States has endorsed, right? The agreement not to deliberately blow up your own satellites with ground-based missiles, creating debris. I think there are opportunities to get further engagement. My hope is that those can start from relatively modest beginnings. So the open-ended working group, I think, was a nice example of bringing people into a room to discuss perceptions of risk and good behavior, and then build that around specific achievable objectives. These might seem to be quite narrow in the beginning, but they could build trust and confidence, which could, in the fullness of time, provide the grounds on which to start to negotiate larger scale agreements. My own view is that it's absolutely essential that we do so, because we really are in an inflection point right now. I mean, the sheer volume of mass in Earth orbit is rising very rapidly. And we could very well find ourselves in a situation before too long when it becomes difficult to operate in low Earth orbit. And that would have huge consequences for human societies on Earth. And so my hope is that that is enough of a spur to get actors moving in the right direction. My view would be that the most productive way forward right now is to think of this in terms of initially developing voluntary norms that articulate appropriate forms of behavior or inappropriate forms of behavior. And maybe, if conditions allow in future, we could look towards legally binding mechanisms down the road. But I think until we have a greater sense of common views on right and wrong behavior, and until there is some measure of trust built up, legally binding mechanisms don't appear to be viable, unfortunately.
Adam, many thanks for your insightful thoughts that you shared your research with us. I think space is and will remain always a slightly mysterious place to research, because the problem is that we can't just go there and have a look. That's not that easy. So therefore, I'm very happy that we could process this episode and we could elaborate on the governance of the space. I hope that space will not be armed, because as we know, there are many actors who would like to see some weapons and some perhaps conflicts in the space. Adam, again, thank you very much for being an IO thinker.
Thank you so much for the time.